Let's call this meeting of the House Finance Committee to order. Let the record reflect that it is 8:37 a.m. on Wednesday, April 13th, 2016. Present we have Representative Wilson, Vice Chair Sadler, myself, Co-Chair Thompson. We have Co-Chair Newman, Representative Guttenberg, and Representative Gaddis. So we do have a quorum. Please make sure your cell phones are turned off. No electronic devices allowed in committee. On today's schedule, we have SB 170, DNR fees for geological. We have House Bill 194, Alaska Securities Act, penalties, certain rules, and HB 311, sustainable budget reporting. First, we'll have Senate Bill 170, DNR fees for geological, by Senate Resources. Here to present the bill is Ike. Staff to Senator Giesel and Senator Giesel. Also, we have Steve Masterman, State Geologist, Division of Geological and Geophysical Surveys, Department of Natural Revenue, and he is online. Senator Giesel and Ike, place yourselves on the record and we'll hear your bill.
Thank you so much, Mr. Chairman. For the record, I'm Senator Kathy Giesel, Senate District N, that's House Districts 27 and 28. Mr. Chairman, Senate Bill 170 is another step toward making our revenue-generating department, that's the Department of Revenue, which is one of my favorite, actually, even more revenue-generating.
Natural resources.
Oh, did I say natural? What did I say?
Revenue.
Revenue, pardon me. I meant natural resources. Oy, it's just getting so... Anyway. Back to the Department of Natural Resources. Yes. Well, revenue, speaking of revenue, this bill helps the Department of Natural Resources become even more revenue generating. In fact, hopefully self-supporting in the very near future. The Geologic Materials Center is where our rocks are kept, samples of our rocks, which sounds pretty boring, but it's actually fascinating, especially if you're a geologist, because you can read them like a book. The materials were kept in connexes in Eagle River for a number of years, unheated, unprotected. They were degenerating. So a couple years ago, when the Sam's Club in East Anchorage closed, DNR was offered the opportunity to purchase it at a really reduced price, which they did. It opened a couple years ago. It's fantastic. And other states, such as Texas, have at least one of these type centers. Texas has 2 or 3. They are like a library. Companies as well as agencies come to the GMC to look at the rocks, and then with the information they glean from reading these rocks can go forward in terms of finding more minerals and resources. Repsol actually found promising materials in the GMC which led them to their discovery recently on the Colville Delta, which they are partners with Armstrong. They believe there's 500 million to anywhere up to 3.7 billion barrels of oil there, possibly the largest oil field since Prudhoe Bay. It all started in our GMC. So what this bill will allow is the Department of Natural Resources to charge folks to go into the GMC and view our rocks. They found, that was always the plan, but they found out when they started to do this that they needed legislation. So that's the purpose of the bill. We did make a change in the bill in resources, and that's on page 2, lines 25 and 26, allowing for students to be able to access the GMC for learning opportunities. Classes come to the GMC to take a look at stuff and hopefully be inspired to be geologists. You'll see that there's a fiscal note which indicates revenue receipts. Mr. Steve Masterman, the state geologist, is online. He can explain to you how this will eventually go to the Public Building Fund, et cetera, which is way over my head. Thank you very much, Mr. Chairman.
Thank you, Senator. Questions from committee? Representative Newman.
Thank you. Welcome, Senator.
Thank you.
I'd like to refer to this as the Rick Swenson building, huh? Rick worked hard to get this done, and
He sure
I
did.
remember him talking to us about the connexes and trying to get this. I like the concept in there. Does this? They said this was part of the original plan on that, so they've got a. Excuse me, it's noisy out. They have a place set up where people can come in and look at it. Regular viewing areas then, or what would happen at the building if I wanted to come visit it?
Through the chair, Representative Newman, yes, there are shelves and shelves in this building. It's like a warehouse, but then there are viewing rooms where companies can say, I'd like to view the cores from certain areas. The staff there would set up these cores in the viewing rooms, and then companies or geologists or federal agencies, students, all can come in and look at the rocks.
Thank you. Further questions? And we do have Steve Masterman online, Director of Division of Geological and Geophysical Surveys, if you have questions for him. Seeing none, Senator, thank you very much. At this time, I'm going to open SB 170 for public testimony. Does anyone in the room like to testify to SB 170? Seeing none, is there anyone online? Nobody is online, so we'll close public testimony. Does the sponsor, well, no. Rep. Sadler, can you walk us through the fiscal notes?
Thank you, Mr. Chairman. I would. Senate Bill 170, version W for whiskey, has a single fiscal note from the Department of Natural Resources. The appropriation is for fire suppression, land and water resource, allocation, geological and geophysical surveys. The OMB component number is 1031. It includes increases in revenue, which are noted on the sheet.
All right, thank you, Representative Sadler. We were joined by Representative Pruitt and Representative Kawasaki. Rep. Newman.
Chair, I'd like to move committee substitute for Senate Bill 170, Resources version 29 LS 1400 / whiskey from House Finance Committee with individual recommendations and attached fiscal notes.
Are there any objections? Seeing none, we have moved Senate Bill 170 from committee, and with that, we'll take a brief at ease while we sign the paperwork. We're back on the record. We will now hear House Bill 194, Alaska Securities Act, penalties, certain rules by House rules by request of the governor. We have a CS for this bill, version G. Representative Sadler.
Mr. Chairman, I move we bring the CS for House Bill 194, Finance Version 29-GH1060 \G before the committee for discussion.
No objections. We'll be addressing the CS. Mr. Anderson, would you please come to the table, put yourself on the record, and walk us through the changes from version I to version G?
Thank you, Mr. Chairman. For the record, I'm Brody Anderson, staff to Representative Steve Thompson. Before the committee today is CS HB 194, version G. The CS is for correcting language that came from a conceptual amendment in the previous committee. We have spoken with the previous committee and with the department to correct the language. Both corrections are found on page 100. Excuse me, 101. The first change is page 101, line 2. It deletes the word 19 and inserted the word 18. And that would be referring to the age of an 18-year-old, which is to reflect the age of maturity. On page 101, line 5, deleted the word or disappearance and inserted the word dementia or Alzheimer's disease. And once again, that was for the proper language to the intent of the conceptual amendment. Mr. Chairman, those are the changes for CSHB 194 Finance, version G, and the department is prepared to speak on the bill in its entirety.
Thank you, Mr. Anderson. Here to present House Bill 194 to the committee is Ms. Kevin Anslem, DCCED Division Director, Banking and Securities. Please place yourself on the record and tell us about the bill.
Sure. Good morning. My name is Kevin Anselm. I am the Director of the Division of Banking and Securities for the Department of Consumer Business and Economic Development. I'm pleased to outline the provisions of the proposed Alaska Securities Act rewrite. I know it looks huge, but it really is a rewrite, so most of the language is the same. And I'll first outline some of the changes and overviews the bill for you, and then give you some background about the securities industry in the state of Alaska, and then would be happy to go through a sectional or whatever the committee would prefer. So as a brief overview, this rewrite separates the securities statutes from the Alaska Native Claims Settlement Act, the ANCSA-related statutes, to reduce confusion and improve understanding of both acts. So it lifts the securities provisions out of 4555 and places them in a separate chapter, 4556. It synthesizes the Securities Act with other states' laws through the adoption of significant portions of the Uniform Securities Act of 2002 to make it easier for businesses, entrepreneurs, and investors to understand their rights, responsibilities, and opportunities in Alaska. It recognizes and incorporates current securities industry terms and standards. It has been a while since the Securities Act has been truly reviewed. In fact, we still have references in the Act to notification by telegram. Further, the new rewrite opens equity crowdfunding opportunities to Alaskans. It detours investment scams using Alaska entities or harming Alaskans by increasing civil penalties and providing resources from those penalties for investor, consumer, and entrepreneurial education at the discretion of the legislature. And finally, it enhances penalties against those who harm older Alaskans or vulnerable adults up to treble the statutory amount. A little background about the securities industry in Alaska. At the end of fiscal year 2015, we had 1,234 broker-dealer firms registered here. That's the Merrill Lynch, Morgan Stanley firms. We have only one broker-dealer firm domiciled here, so most of the business comes from out of state. We have 765 investment advisors. About 30 of those firms are domiciled here. And here's the big number. These are the number of salespersons licensed in the state of Alaska as of the end of the fiscal year. 90,340 stockbrokers and investment advisor salesperson. We have less than 1,000 of those domiciled here. Now that includes the... I'm sorry, would you like me to go over the numbers again? Yeah. Okay, I will try not to do that. I'll stay very close to the microphone. Thank you. So we also receive about 6,600 securities filings every year. Most of those are out of state, some are in state. And in general, this is a large and generally compliant industry group for the state of Alaska. I know that you're interested in the submitted fiscal note that is indeterminate, so I'll outline the financial pieces of this industry. Totaled, the securities industry pays about $13 million a year to Alaska in licensing and filing fees. We're not anticipating any change in that amount from this bill. The budget for the Division of Banking and Securities is about $3.5 million per year. We also investigate and, if appropriate, take enforcement action against securities firms, agents, and issuers. In the last 4 calendar years, the division took 54 actions against securities-related firms and salespersons. Most were settled through consent agreements, many of which included civil penalties. All civil penalties go directly to the general fund, not to the division or the department. There were 6 cases that didn't settle, and so we did take default orders against them. I'd like to give you a flavor of the kinds of cases we're talking about. I'll tell you about 3 of them. The reason this is important, besides the fact that in each scenario Alaskans were ripped off, is that the current maximum fine is $25,000 per respondent, no matter how many violations are committed or the extent of the violations. So first, I'll tell you a little bit about Fortune Oil and Gas. On February 3rd, 2014, the division issued a final cease and desist order that included the maximum civil penalty of $25,000 against respondents for selling over $3.1 million in unregistered limited partnership interests in Texas oil and gas ventures, mainly to Alaskan investors. $3.1 million, $25,000 civil penalty was the maximum we could assess. Global Arena Capital Corp. On October 23, 2015, the division issued a final cease and desist order that included a civil penalty of $150,000 against Global Arena and 6 of its employees for violations of the Alaska Securities Act. Specifically, an employment of Global Arena contacted an elderly Alaskan halibut fisherman who was in poor health and sold him junk bonds, although the investor believed he was buying something like a CD. The investigation revealed that the agents were instructed to offer and sell junk bonds as safe investments. The fisherman invested $27,000 in those bonds, which rapidly lost value. The firm even attempted to sell the investor other bonds, including one that would not have reached maturity until this elder investor was 119 years old. The investment lost nearly $16,000. Global Arena was cited for deceptive and misleading representations and offering unsuitable securities. Currently, the division can only get money back for a defrauded investor with an agreement with the bad actor to pay restitution directly to the investor. In this case, the division was successful in negotiating with one of the 6 respondents to pay restitution to the investor, so he got his money back. The division may be able to recover some of the penalties through a SIPC action now, since the firm is now out of business. So $16,000 back to the investor, which was a big win. But for the state, of the $150,000 in civil penalties, none so far. What was interesting is that then, with Garden State Securities, a man named Garland James, previously an agent at Global Arena Capital, that was the one that just sold the junk bonds to our Alaskan investor, he went to work for Garden State. He cold called that same elderly Alaskan that was fleeced by Global and tried to sell him $82,000 of a risky biotech stock. When he made the call, James was not even registered as a broker-dealer agent in Alaska. He wasn't one of our 90-plus thousand. The division entered into a consent agreement with Garden State to withdraw its registration in Alaska, the broker-dealer, and pay a $25,000 civil penalty. That was the maximum for failing to supervise James. The division issued a temporary cease and desist order against James on March 21st, 2016, just last month, for unregistered activity and for offering an unsuitable security to the investor, seeking that $25,000 civil penalty. And I'll tell you about another case, a little bit different, relating to Troy Stafford and Patrick Williams. Stafford and Williams formed an Alaska LLC called GS Capital and WS Seafood. Stafford offered an Alaska resident an opportunity to invest $40,000 in the seafood and also an option for some employment. Stafford also stated falsely that another corporation had promised a $10 million loan to assist the endeavors. The investor ultimately lost his money. The deal fell through, and the investor never received the promised management role. The division negotiated a settlement with the respondents requiring them to offer rescission to the investor, which the respondents agreed to do and promised to pay. They even filed the notice of rescission with the division, but respondents never paid. The division issued a cease and desist order and received a court order to enforce it. But at this point, there was no requirement in the statute that they actually had to pay. So that's another change that we're looking for in the current bill. The orders from these cases and more are on our website. This bill would change the maximum civil penalty per violation to $100,000. You can see that with the kinds of cases that we're talking about, there would be a wider range of potential civil penalties. The fines imposed for the 6 cases I mentioned, of which I told you about 3, were $525,000. Under the provisions in House Bill 194, the potential fines could have reached over $7 million because of the number of violations that were involved, particularly with the Fortune Oil and Gas, which, by the way, we are in litigation over the $25,000. Of course, one never knows what can actually be collected, and so we can't promise revenues with any certainty, thus the indeterminate fiscal note. I realize that I've been talking for a while now. I do have a statement of changes that outlines the amendments to the bill from the beginning of its introduction. There aren't that many, as well as a brief sectional analysis that I would be pleased to share. Also on the line today, I have Renee Wardlaw, who is the Assistant Attorney General that works with us at the division, and Christy Naylor, the division's Enforcement and Securities Chief. How may I best assist the committee?
Thank you for your presentation. Seeing as how we're so late in the session and this bill still has to go to the Senate, how important is it that this bill becomes a statute this year and gets passed on both sides?
I consider it critical. The division has worked for a number of years to try to get the securities law updated. I believe that not only do we need to protect our investors and our state from problems in the securities industry, but I also believe that we can help with revenue generation if we can assess those individuals and companies that wrong Alaskans with increased civil penalties.
Questions from committee. Representative Sadler.
Thank you, Mr. Chair. I'd like to ask Ms. Ansel if she would speak a little bit more about the Alaska-specific elements of this. As you say, you probably build off the Uniform Securities Act, but what are the Alaska-specific provisions?
Most of the Alaska-specific provisions have to do with exemptions from registration because there are, for instance, and I can go through a number of them, I can pull them up, but we have special exemptions for certain fishing cooperatives, for CFAB, the Commercial Fishing and Agricultural Bank, as far as their securities needing to be registered. There are some mining exemptions. None of those changed. Those carried over from the original act. I can get you a full list of those if that would be helpful. Representative Sadler.
Representative Sadler.
Another line of question. Yes, I would like to know more about the Alaska-Pacific, but also looking at this and not having given it the attention I'd like to give a bill. I noticed it has 32 sections. To echo the chairman's question, are there specific sections or elements of the bill that are more critical than others? I know you've put forth a large bill, an omnibus bill, that often they interact, but if you can give us some sense of priority, what is the most critical of the
Understood.
105 pages?
Yeah, I understand. The enforcement provisions are critical. The crowdfunding is critical, although I will tell you there is another bill pending relating to crowdfunding from the Senate. The ones that are not as important, because they're very, very similar to the current act, are the exempt securities sections. So Article 1, Article 2, other than the crowdfunding. Article 4, which has to do with the broker-dealer licensing, most of the agent licensing, most of that stays very similar. There's a few kind of new options relating to it clarifies when a broker-dealer can have a few clients up here without being separately licensed with us. So it's primarily, the other big piece is allowing up to a third of the civil penalties to be, I don't want to use the term earmarked, but can be allocated by the legislature for consumer and investor education. That is one of the pieces that is part of our mission that we have no way of funding at this point. And so the way that the bill outlines the civil penalties is that up to a third of those civil penalties can be put in a separate account, still under control of the legislature, to potentially be used for ongoing consumer, investor, and entrepreneurial business education.
Representative Sadler.
Thank you. A final question. The Uniform Securities Act, are there elements of the bill that are necessary to comply with any? I know there's been a lot of changes in consumer laws and securities laws at the federal level in recent years. Are there elements of the bill that require conformity with federal requirements?
I hesitate because there are a number of federal requirements that have evolved over the years, but that are already referenced in the bill. So I don't know if there are any specific federal requirements that we're trying to address here. Securities law, if I may, securities law has basically two components. It has a federal overlay, and then there's what's called the blue sky law. And the blue sky law is what all of the states administer. And so there is a layer of securities that are generally nationwide, deal with high-moneyed individual investors that have the protections of the Securities Act 33, 34, and the 1940 Act. And so there are areas where the state is preempted from dealing with securities. However, the smaller, more localized, I think is the intent, securities laws are handled by individual states. Of course, it helps for business practices to be synthesized with the other states so that, again, like you're seeing with our broker-dealers and with many of the issuers that I've mentioned, that they can cross state lines and still be in compliance with both federal and state law.
And lastly,
Representative Sadler.
I think the Uniform Securities Act, is that, we often have, we have the Council of State Governments and the National Conference of State Legislatures and the Council of State Governments who sometimes put out uniform laws or recommended laws. Who produces and administers the Uniform Securities Act?
And I'm going to, since I know that I have staff online, I'm going to ask if they'll go ahead and give you the name so that I don't mess it up.
Which one would you like, Ms. Naylor or
Ms. Wardlaw? Either.
Wardlaw? Are you there?
Yes, good morning. Through the chair, it actually is an accusal.
Pardon? Couldn't hear you.
Oh, good morning, and for the record, my name is Renee Wardlaw. I'm an Assistant Attorney General. I actually am here in the room with the Chief of Enforcement, Christy Naylor, and in fact, the answer is it is an accusal.
We could not hear you. Get a little closer to the microphone or whatever.
If I may, Renee, would you please give them the full name, which is why I didn't have it in front of me and didn't want to mess it up, instead of the acronym?
Sure. It's the National Conference of Commissioners for the Uniform State Laws. and hopefully you can hear me a bit better now.
Yes, thank you.
Thank you.
Wonderful. Thank you so much.
Okay, Representative Wilson.
Thank you, Mr. Chairman, and I know this might be important, but I'm just going to put on the record, I have not vetted this bill as well to pass it out today.
We'll talk.
It sounds like it has a whole lot of changes. But on the portion of the criminal enforcement, part of the information we did get yesterday, it has a certain provision that changes willful violation to knowing violation. That's a pretty big change. So can you explain why that change?
Through the chair, Representative Wilson, of course. The Uniform Securities Act included the term willfully. When we were working with Ledge Legal, they asked us to change it to knowingly. So willfully means intentionally, knowingly is knowingly. And in the hierarchy of mens rea, in other words, the state of mind, intentionally is the highest, so willfully is the highest, and next is knowingly, then recklessly, then negligently.
So follow up?
Representative Wilson.
So we're lowering the standard of what it takes to, I'm assuming, to get a conviction or whatever the department does if they feel something has been done wrong?
Yes, and the criminal statute is reflected there in AS 11.81.900.
Okay, and follow up?
Follow up, Representative Wilson.
So I heard some of the stories that you gave, and so I'm trying to figure out for a conviction, is that merely a determination by the department, or does it go through some kind of court proceedings before it's determined how much money is needed to be paid back, or even if there's a violation?
Through the chair, Representative Wilson, there are three different types of actions that can be taken. First is administrative, and that is through the department. The second is civil, which can be either the department or through a private cause of action. And then third is criminal. And while the department can take criminal action, that's not been something that we have been doing. We haven't had the right case or the resources to do that at this point. There have been other, obviously, the Department of Law can take criminal action if a case arises in a different context besides coming up through the department.
So follow up?
Representative Wilson.
So if I understand you correctly, and I'm still trying to wrap my head around all the different things, so the department, through an administrative process, could end up finding someone guilty on that level, and the change now can be up to $100,000 restitution, and then is there a fine also that the department can then enter?
Through the chair, Representative Wilson, the civil penalty would be up to $100,000 per violation, although typically, as you can tell, we do negotiate those things if we can do it on a consent basis. Restitution is different. Restitution is usually a payback of the money that is lost. So there could be restitution and a fine. That's a possibility.
Okay, and a follow-up, Mr. Chairman?
Representative Wilson.
So if someone goes through the administrative hearing and they're found knowingly now to be guilty, do they have the opportunity then to appeal to a court, or can they just appeal to the department?
Through the chair, Representative Wilson, the administrative way that happens is basically to the department through the Office of Administrative Hearings, and then if the Office of Administrative Hearings decision can be appealed to Superior Court.
Representative Wilson.
I have big issues when we're allowing administrative hearings to be able to find someone guilty, and then they have to go through an appeals to the Superior Court, which could become very costly versus a court making the judgment. I mean, to me, that's just, we've got issues with that throughout on these administrative hearings, and I'll just list everybody else's question, but it just makes me very uneasy.
Welcome, Representative Edgman. Next, we have Representative Pruitt.
Yeah, thank you. This is a lot to try to soak in, especially from our perspective here. So a few things that I want to go back. You really rushed through quick on the examples there, and so I tried to write them down. So I'm going to try to go back to one of them. What I want to understand is, for those scenarios that you've highlighted where there, obviously you indicate things that it sounds like we need to effectively try to do something different. How would this bill handle, or what would they do different, both for the individual that was harmed as well as for the state? I mean, like I think you mentioned you mentioned one about there was, Garden State, and there was an individual that had been let go, and then they were hired by Garden. There was a series of events with that elderly gentleman. What would have been different for that elderly gentleman and for the state with underneath this, as opposed to what you were able to do?
What would have been different if this law had been in effect, or these provisions would have been in effect? We would have been able to order restitution from the firm, which is probably what we would have probably ordered it from the firm. We would have also fined the firm for failure to supervise, and then there were several layers of supervision that there were managers that were telling these young and inexperienced brokers to go out and sell this stuff. And so we would have taken actions against each of them for those violations. And depending on what we were able to find their ultimate culpability, would have adjusted the fines accordingly.
Representative Pruitt.
So, and I don't, Garden State, is that one of those, is that a firm that is one of those that you had highlighted that is registered outside of the state or from outside of the state?
Yeah, they're a New York firm.
Yeah, okay, I just didn't want to assume that. Mr. Chair, that's what it sounds like. But so how do you ensure when either a broker or a broker's firm or whatever it is that's outside of the state, and that's where they're based? You mentioned, I think, 90,000 people are licensed here, but we only have 1,000 in Alaska. How do we ensure that we're able to deal with those people that live outside of the state? Is that part of the uniform law? Does this also give us the ability to work with other states through, I mean, in some, whether it's, in some cases we do interstate compacts, but does this also assist us with that ability to go after those that may not be resident within the state?
Through the chair, Representative Pruitt, yes. And there are also some national organizations called the North American Securities Administrators Association that all of the securities state departments work with, and we have very strong agreements to work together, because so often this sort of thing isn't happening just in one place. And so we compare notes and we do joint investigations as needed.
And
Representative Pruitt.
last question. Thank you. That's kind of shedding a little bit of light on a very large subject. Final question that I had, and probably slipped my mind, but that's probably the lack of sleep. I'll remember it, Mr. Chair. Come back.
Thank you, Representative Newman.
Thank you, Mr. Chair. Welcome, ma'am.
Thank you.
So, did I hear you say something that it creates a board or a committee earlier in this bill? I thought I heard that mentioned.
Through the chair, no, Representative Newman, there's no boards or committees established with this bill.
Good. Mr. Chair, I have a couple questions.
Representative Newman.
Is there any businesses currently, thank you, Mr. Chair, is there any businesses currently working in Alaska that would be affected by this? So we see changes in laws like this generally because of specific instances that happen. You've listed a few probable instances. Is there any ongoing in Alaska right now that would be affected by these changes?
Through the chair, Representative Newman, any of the changes that take effect here or through this bill would not take effect until transactions happening on and after the date of the effective act. the date of effectiveness of this act, which right now is set to be July 1 of 2016. So anything that has happened in the past or that is currently in process would not be affected by the new provisions.
Mr. Chair, a couple questions.
Representative Newman?
Thank you, Mr. Chair. Ma'am, I believe what I read in one of your handouts is they would not be required to have an Alaska business license or an Alaska license to practice in Alaska with this?
Through the chair, Representative Newman, that is actually in the area of the CBPL, the professional licensing area, and whether they need to have a business license or not. I know that most of the firms that work here do have a business license with the state of Alaska, and that is one of the things we check.
Thank you, Mr. Chair. I just noticed that
Representative Newman?
I just noticed that it had what it called a snowbird carve-out in
There
here.
is a snowbird carve-out, and that is, again, for firms that have clients in another state. They may come here for a short time and may do up to 3 transactions without having to be separately licensed.
One more, Mr. Chair.
Representative Newman?
Thank you, Mr. Chair. Under current state statute, money received from the state from court judgments goes into the general fund. Does this bill change that?
Through the chair, no, it does not. All of the civil penalties go to the general fund.
Thank you, Mr.
Civil
Chair.
penalties are what goes to the general fund.
Yes.
Thank you, Mr. Chair.
Thank you. Representative Guttenberg?
Thank you, Mr. Chair, and thank you, Ms. Elsom, for being here. Mr. Banks
Your
with,
microphone, would you pull it a little closer, please?
thank you, Mr. Banks with Samuels, Yolen, and Cantor writes a nice letter. Thank you for coming to join us in Alaska. He goes on about variable annuities, and he lays it out. He lays out the problem and the difficulty in understanding the contracts, both for the customers and the agents selling them. Why do we even allow variable annuities here? And just to follow up on that, he starts off by talking about Section 4556-605F, and I can't find F in either the bill or the spreadsheet provided on the changes. Maybe it's because it's been deleted.
Through the chair, you're exactly right. We've worked with the insurance division is the primary regulator of variable annuities, and while variable annuities are a security on the federal level, states may or may not regulate them depending on what provisions of the Uniform Securities Act are adopted. Working with the insurance industry, they asked us to not engage that provision at this point. So we're working closely with the insurance division, and we have all along to ensure that those are properly regulated on the insurance side.
Representative Guttenberg?
Follow through. Well, Mr. Banks goes on. I mean, this is all, this is the first time we've heard this. I think maybe we're the only committee to hear it. And he says that section is very important. So if you're not doing it in this bill and it's moving over to Division of Insurance, how is that being covered?
Now, through the chair, Representative Gutenberg, right now, insurance is the sole regulator and has been since the beginning of Alaska time.
Okay. But
So-
this, so if I may, Mr. Chairman, this bill doesn't have to just deal with banking. The sections can deal with other regulation or statutes that cover other people. So is there something that's left out that we should put in that would deal with that in whoever regulates it? Where,
Through the chair, Representative Gutenberg, probably not at this point. We're going we've agreed to do some additional research, and I expect that we may well be coming back to the department and to this body relating to variable annuities.
So if I may also, Mr. Chairman, one more question.
Representative Guttenberg?
So, a lot of what I'm seeing here has to do with conforming to some of the national standards. if variable annuity is as problematic as it seems to be, well, do we have a history of problems in Alaska with variable annuities, and why should we wait? And why would it be left out from a conforming national standard?
Through the chair, Representative Gutenberg, what has happened with other states has been, I hate to use the term variable, but has been different depending on the state and depending on the strength of the regulatory scheme that is in place. The variable annuities are regulated on a national level through both the SEC and through the equivalent of the former National Association of Securities Dealers. So they are, and there is still a licensing requirement. So we license the variable annuity salespersons through securities. They are also licensed through the Division of Insurance. The Division of Insurance under Chapter 21 has the primary and at this point sole requirement to regulate variable annuities. Adding variable annuities into the 4556 would be an addition. And in talking with the insurance industry, the decision was made jointly with the insurance division and the industry to see how the regulation was going and to do some additional study to see how well it's being regulated here in Alaska.
In the first part of that question,
Representative Gutenberg.
do we have a problem with the sale of variable annuities in Alaska?
Through the chair, Representative Gutenberg, there have been complaints. I don't know that I would call it a problem.
Okay. Thank you, Mr. Chair.
Thank you, Representative Gaddis.
Thank you, Mr. Chair. And this is a big bill, and it's the first time that we've heard it. And I guess I'm going to piggyback on my colleague from Eagle River. Is there any particular section in this bill that if you were king of the forest just absolutely has to pass this year, or something bad will happen? And I know that he asked, you know, but I guess with 4 days left, I struggle with the fact that we've got some big things that we also need to address, and I just want to be sure that we do our due diligence at the same time that you. To me, this looks like that there's some cleanup in here. You know, when you talked about, you know, there's rules that talk about notifying by telegram. So, I mean, I see that cleanup aspect, but what in here just has to happen, or we do some really bad things to Alaska?
Through the chair, Representative Gaddis, first I want you to know that this bill had a number of hearings through House Labor and Commerce, followed by a number of hearings and some amendments from the House Judiciary Committee. So there have been a number of your colleagues that have been looking at this bill very closely, and I very much appreciate that. The biggest areas for us to be able to properly regulate the securities area has to do with what we can do as far as enforcement, because right now, for people to come up and rip off Alaskans is merely a cost of doing business. Second, the division expends a lot of time and energy doing those actions, and it's important that the state, if it can, collect the appropriate civil penalties that go to the state, as well as making sure that our investors can be made whole through restitution or the appropriate sorts of rescission offers. So really, we're looking about the protection of Alaskans here. Additionally, we'd like to be able to do more with consumer education using a portion of those funds to help keep Alaskans from being ripped off in the first place, to let them know they've got resources and how to use them.
So if I might,
Representative
Mr. Chair,
Gaddis.
and I'll keep this real short because I know we're limited for time, and I appreciate the letting us know about Judiciary and Labor and Commerce, but there's a lot of cleanup in here. But the two things that you mentioned, you know, we would always want to do that, so it's not necessarily pressing this year. It could have been pressing last year or the year before, type of a thing. And so I guess I'm asking, is there something that we're trying to line ourselves up with the feds, or some reason that it's pressing this year? That's where I'm really trying to get at. And, you know, I know that we're spending a lot of time on a big bill and we're trying to do our due diligence, but we're just trying to find out where to really hone in.
Through the chair, Representative Gaddis, this has been in process, I can tell you, for at least the last 6 years, to bring us in compliance with the most recent Model Act of 2002, so that we can work more closely with states so that our law is more aligned. Additionally, it's important for economic development that people who want to offer securities here or to grow businesses here know that our state is relatively in line with everybody else. Now, there is one other provision that we haven't talked very much about, and that's the crowdfunding opportunity for Alaskans. And crowdfunding means that Alaskans in-state can invest in in-state businesses. They can invest under this bill up to $5,000 per year in an Alaskan business that has been properly filed with our office. And so we'll help some of the kind of the intro economic development that the state is looking for. So in addition to the enforcement areas, it is important to look at the crowdfunding piece. But as I mentioned, there is already a bill that is going through Senate Bill 126 that is sponsored by Senator Costello that she actually originally introduced a couple of years ago.
Sure.
So enforcement, sorry.
Go ahead.
Just the enforcement provisions, the Model Act provisions. Crowdfunding is important, not critical, but crowdfunding is important. As you know, there's a number of states, I think about, I'm going to say 25-ish or so, that now have crowdfunding across the country. And that is a state-only thing.
Thank you, Representative Gaddis. Representative Munoz.
Thank you very much. So the number 90,000 registered agents really kind of draws my attention, and I'm wondering, is that an unusually large, I mean, per capita group of registered agents comparatively to other states? And if so, why is it that Alaska is attracting such a large number of these agents?
Through the chair, Representative Munoz, it is a larger per capita number, although I have to tell you that states that are more populous than us have far more representatives registered. But you know, one of the biggest draws that we have here is our high per capita income and higher per capita net worth, because we are smaller, but we also have higher incomes and other resources here. And so we are a target. There is no doubt about it.
That's interesting.
And without good, solid enforcement opportunities, I think we'll continue to be a target.
Okay. And then, Mr. Chairman, and then on the crowdfunding issue, is that not current practice? Would this be the allowance for crowdfunding would be provided in this change, but it's not currently state law? Is that what I heard you to say?
Through the chair, yeah, it is not currently state law. The only, quote, crowdfunding that can be done is through websites like Kickstarter, where basically you contribute to someone's project or new idea, and perhaps you'll get back, for instance, a videotape, or you'll get an example of the product that they expect to produce. But they don't expect to get any return on their investment, so to speak. Whereas with equity crowdfunding, or crowd investing as it's sometimes called, investors can expect to, or do expect to, either get money back either as interest on a debt obligation, or being able to participate as the company grows and there are dividends or other remuneration that can come back to the investor.
Okay. And Mr. Chairman,
Munoz?
is that with crowdfunding, with the proposal, is it 5,000 per investment, or is it a cumulative cap?
It is $5,000 per investment.
Per investment, okay. And then my last,
Munoz,
thank you,
another.
Mr. Chairman. And then my last question, you mentioned several cases where individuals had been taken advantage of. Do they come to your division, or are there other ways that you have access or, gain information on these cases?
Through the chair, Representative Munoz, we oftentimes, often the cases are referred to us through law enforcement, federal and state. We do get complaints in as well. So we do have to find out about the problem before we know there's a problem. Now, other times we do get referrals from, for instance, the Securities and Exchange Commission because they receive a complaint from an Alaskan investor. We just got one the other day that ended up with the National Association of Securities Administrators that was passed on to us. So we get them from a number of sources.
Thank you, Mr. Chairman.
Thank you. Representative Sadler.
Thank you, Mr. Chair. Briefly, Ms. Anselm, you mentioned a couple times that this would help improve, or I wouldn't say dedicate, but designate certain funds for consumer education, but the fiscal note does not have any reference to where those funds would be. So could you help me understand how much, what the actual source of the funds for consumer education would be, how much they would be, and how they would be expended? I'm not quite sure where the consumer protection function exists in state government now.
Through the chair, Representative Sadler, it's actually part of our mission, the stated mission of the department for consumer protection. But where the money would come from is, for instance, we'll just use one of the $25,000 penalties. If there was a $25,000 penalty, then about, 8,000 and change could be designated into an account that is for consumer education. And again, that's general fund, so it'd be a general fund sort of account that is under the control of the legislature. And then the legislature would determine through the budgetary process whether or not money should be allocated to the division to do those sorts of outreach events. I can give you some examples of the outreach events that we've had the opportunity to get grants for.
Actually, at this point, thank you, no.
All right.
But I would ask if you have any estimation of how much money you're likely to have. Obviously, it depends on enforcement and so forth, and you might say if you give us the better enforcement authority, we can get a better idea, but give us your best shot at this point, how much money we're talking about.
Well, I can tell you that if we looked at historic information, that we had potential fines. If we had potential fines, if we did maximum fines for the cases that I was telling you about, there would have been about $700,000, about $7 million worth of fines during that 4-year period, 2012 to 2015. And then a third of those fines could have been moved into investor education, or could have been used for something the legislature needs money for. And I don't know, given the current state of affairs, I'm thinking that we wouldn't be using it for consumer education. I'm thinking it probably would have gone to budgetary needs right now.
Thank you, Mr. Chair.
Thank you, Representative Sadler. Representative Pruitt.
Yeah, thank you. Actually, first, how long have you been working on this particular piece of legislation? I know you said there was a Uniform Act back in, I think, 2002. How long has you've been working on putting this one together?
The work on this bill started before I came into this position back in 2011. So it has been in process since, I'm going to say, around 2008. There have been several attempts to bring the Uniform Act forward.
Okay. Continue.
I think I was on Judiciary and heard a version of this 6 years ago. Representative Pruitt.
So one of the things you talk about the orders of restitution, specifically for an individual. How do we ensure that that individual gets their money back at this point? How does that change with what we're doing here? I mean, just an order of restitution is one thing. How do we ensure that that person is able to be made whole?
And that, through the chair, Representative Pruitt, there is a change in here that says that the money has to actually be paid before the division's action or other action goes away. And that was not specified in the law, or isn't currently specified in the law, which is why we had the issue with the two individuals, Mr. Stafford, that did not pay, said they would, filed the documents, we approved the documents, and then didn't pay. So then we have to circle back around and take another action.
Got it.
Representative Pruitt.
And then on the crowdfunding piece, are we taking in this bill, are we basically taking what other states have done and kind of doing a mirror image of that? Or have we done some other things, adjust it to Alaska? I don't know why you'd need to do that, but just, how does this compare to what's out there?
Through the chair, Representative Pruitt, actually, we chose more the simpler route. There are a number of states that have more requirements than what this act would impose, and different limits. There are states that only allow up to $2,000 of crowd to be invested, and there are a number of other requirements for the business. One of the things that we have here in Alaska is things are relatively transparent. We don't have that many people up here. It's easy for us to see what's going on. This bill does not require an escrow requirement, but it requires information about all of the control people and about the business itself. But as far as a business plan, it doesn't go to the level of a prospectus that one would have to have in order to have securities approved by either or filed with the Securities Exchange Commission, or even under our normal registration procedures. So it is a simpler process to help get entrepreneurs off the ground. And again, we don't have, I'd say that we are in the lower quarter of substantive requirements to get that started. The other thing that we're allowing that other states don't is we're allowing people to use Craigslist, for instance, to advertise in Alaska. Some of the states have gone more the federal route and require it to be offered through a broker-dealer. The cost for that is phenomenal. So we're trying to keep it simple and still have the information so that we can make sure that the business information that's provided to the investor is accurate. We can't say that a business will for sure succeed, obviously. We are a full disclosure state, but we're not, quote, a merit state.
Yeah, and follow up on that.
Representative Pruitt?
So how do we ensure then for those consumers? I know it's a much smaller amount, but some person decides they want to put $5,000 in, and they've been told it's a really good thing. What mechanisms are in place to ensure that if something goes sideways, that they're potentially made whole?
Through the chair, Representative Pruitt, the same provisions that we've talked about already. The full enforcement cadre would be there, but of course that's a range, and so we tailor that range.
And then
Representative Pruitt?
And obviously, we're not making it as difficult as either some other states or as we do in other situations. But what is the mechanism to make sure that it's not just some kind of fly-by-night, guys out there trying to, something? It seems like it could be a little bit easier to take advantage of people on a smaller scale, and it's maybe so small that people say, I can't call anyone. I've lost my $2,000 or whatnot, or whatever they may have put in. How do we, since we are making it easier, what are the things that are in place to ensure that we have oversight in some capacity?
Through the chair, Representative Pruitt, there's a filing requirement. And we also, we have securities examiners that actually look through the information. They ask questions if it doesn't make sense, and they've seen a lot of investment opportunities over the years. And so we'll require that information be provided. We also do background checks. We have to have information on all of the control people so that we have an idea of what they're doing. They have to be Alaska residents, not in the PFD sense, but in the being able to register to vote sense. So it's not people that can come in from outside. This is Alaskans for Alaska, as far as this crowdfunding goes.
Great.
Representative Pruitt?
And one last question, and it was related to the education part. You said that was consumer education. How do you do consumer education? I mean, it's not, you think when you think education, a lot of times we think an ad campaign and things like that, and it doesn't sound like we're even talking about that much money to be able to do something like that. How do you ensure that people are educated on something that is probably not spoken about much? There's probably a lot of people that are either fly by night or they just kind of think they know, or they heard it from their friend Joe. How would that money be effectively utilized to educate?
Through the chair, Representative Pruitt, I'll tell you some things that we're doing now, and then you'll you'll be able to see how we can expand that. We, of course, have our website. We work closely, for instance, with the Securities and Exchange Commission. They've come up a couple of times, and we've done presentations and seminars for the military families. We've done them for the public. We work closely with AARP, and in fact, we were able to get some joint grants through the Investor Protection Trust over the last couple of years to produce a series of spots. Actually, they're 30-minute programs that are broadcast through KTOO here through 360 North. And we've done that for the last couple of years. We've done 13 programs a year, and we reach about 250,000 viewers a year with those. We participate in all kinds of community events, whether it's a financial fitness fair or other venue. In fact, if Christy's online, she can probably give us a number. She also does the consumer outreach, not only for securities, but for some of the other things that we do in our office.
Mr. Pruitt, would you like that, or?
No, that's fine. I think it gave me just kind of a broad overview, and I
So
appreciate that.
we do small and large events to try to give people an idea of what's going on, as in addition to articles in the paper, those kinds of things.
Yeah. Okay. Thank you, Mr.
Thank you, Representative Pruitt. Representative Wilson.
Thank you, Mr. Chairman. So you say you've been trying to do this for 6 years, so what's been the sticking point?
Through the chair, Representative Wilson, the fact that it's complex, the fact that doing an entire rewrite is, it's difficult because it looks bigger than it is. One of the other impetuses to getting this done is to help with the Alaska Native Claims Settlement Act statute. It is intermixed with securities and has been a real impediment to updating the Securities Act, because so much of what's in the quote Securities Act really doesn't apply to ANCSA. And so worried about unintended consequences. I've worked with a number of ANCSA representatives, and they're happy to have this split out so that it's clear. And there are some things that they would like to change too. But of course, then the securities industry says, well, what are you doing with that? I mean, why are you looking at that? So I think this is the first time that we've suggested totally separating the two statutes.
And follow up?
Representative Wilson.
And that's my concern today. I mean, I can't tell you if this is a good or bad bill. I honestly don't know. It sounds good. It sounds like things that we need to do, but I don't like passing things along and then say next year we'll relook at it, because next year just, who knows what happens next year. But my biggest concern right now really is we want to protect the consumer, absolutely. But when we start doing administrative hearings versus court hearings, it makes it much more difficult when we start lowering the threshold. That concerns me on, whether or not it's really the level for guilt, that knowingly, and it gets harder to prove, what somebody really knew going into it, unless it's just out and out. Somebody just went and did it state by state, and you can really prove that kind of a portion of it. So, those are just the parts that I just need to personally understand better before I feel like this is ready to go. But I appreciate what you're trying to do. I had a bill like that too that ended up being about 13 words. So I can understand when people are trying to wrap their heads. Did the industry get notification of this and have a chance to weigh in, because it is so big on some of the changes that there are?
Through the chair, Representative Wilson, yes. And that's why we have gotten some feedback. There have been some other letters that have come in as well. And the primary concern was from the insurance industry with relating to the variable annuities. So, and we resolved that concern.
Thank you.
Thank you, Representative Wilson. Okay, at this time, I'd like to open House Bill 194 for public testimony. Is there anyone in the room that would like to testify on House Bill 194? Seeing none, is there anyone online? There is no one online, nobody in the room. With that, public testimony is closed. Okay. This is an interesting bill. It's a huge bill, and I can understand the concerns of the committee. This meeting, this bill has been through multiple meetings in Labor and Commerce, had multiple meetings in Judiciary, and it seems to be pretty well vetted by previous committees. This committee received the bill because it has the physical impact. Attached with it are 2 zero physical notes and a indeterminate minimal impact for revenue. And, you know, I would normally not want to see a bill this large come through this committee, but having been so well vetted before it got here, and this bill protects consumers, protects vulnerable people, gives the revenue, gives opportunities for recovery of funds where people have lost their retirements darn near. And so I'd like to have some discussion by the committee about those aspects and the period of time that we're in with only a few days left in the session, and the need, and the department feels that they can get it through the other body if we hurry up and get it moving. So I would like to have some discussion by the committee on that. Representative Wilson, followed by Representative Gaddis.
Well, you know, I really appreciate those comments, and I'll tell you, I watch gavel to gavel and everything I can to try to keep up what other committees have done, and I know it's been vetted. I believe there's a companion bill on the other side, so it is being moved both ways. But, and again, I want to protect consumers, but I have been here long enough to know that what looks good, and then we pass it, and we just fixed HB 44 about a week ago because of unintended consequences that we had, which turned out to be over $500,000 to our own school district. I can't tell you right now whether that is happening here. And that's really where my concern is. I'm fine personally if we could just bring it back even at the 1:30 to give us at least a chance, you know, to make a few phone calls. And that's what I want to do, because I've learned being here, Mr. Chairman, I can't know everything about everything. But luckily I have caller friends that I can that deal in these kind of things all the time, just to be sure to pass it out that we're not going to be back here next year trying to fix what we try to correct. So again, I think it went through 2 good committees on this side, but I don't sit on either one of those, and we've been quite busy up here trying to take care of all the other things, and I'd like to talk to them as well on the recommendations and just make sure we get it right. So I don't have a problem passing it out necessarily today. I do right now, this particular moment, but I think it's our due diligence to make sure that we understand what we're passing, and it is a rewrite. And on the criminal side of it, we are lowering the threshold, and I just don't know whether that's a good thing or a bad thing. It may be a great thing, and that may be why people are not getting their money back. But again, it may also make it to where we're going to start finding people who did not knowingly do anything wrong and somehow got sideways somewhere else. So, thank you.
Okay, Representative Gaddis.
Thank you, Mr. Chair. And I wouldn't mind a little bit of time to look at it too. And I know that we're short of time. Pulling the votes from both of the committees, and I don't know how many committee meetings they had, but there was a lot of no recs from both sides of the aisle. And I'd like to circle back around and see if they just knew that it was going on to another committee and that's why, or if that there were concerns. So, you know, with a big bill like this and very little time to look at it, I don't want to hold it up, but if we could have a couple hours, I'd be fine with that.
Representative Sadler.
Oh, well, Mr. Chair, I would echo the comments generally about the 2 previous speakers. It is a big bill. I noticed that there's been, I think, 3 committee hearings in the Labor and Commerce Committee over the course of about 7 weeks, and 2 hearings in Judiciary over the course of 2 days. I wish we had more time, but we don't. But I think we can indulge the committee members and have just a little bit more time to review it. So I understand the urgency, and I appreciate the Ms. Anselm telling us what the most critical elements are, but I get more comfort by getting just a few more hours to review it. Thank you.
Okay. Appreciate your presentation today. And with that, I am going to set House Bill 194 aside at this time, and we will be bringing it back under bills previously heard. And thank you. Okay, next we will begin with HB 311, Sustainable Budget Reporting by Representative Millette. Here to present the bill is the Majority Leader, Representative Charisse Millette, and Mr. Brad Keithley, President of Keithley Consulting. Please place yourselves on the record and begin your presentation of the bill.
Thank you.
You want to help him?
Thank you, Chairman. Time, oh.
Brief at ease while we set up the computer. Back on the record, please place yourselves on the record and we'll hear your presentation on House Bill 311.
Good morning, Chairman Thompson. For the record, my name is Sharice Millett. I'm House District 25 representative, and I'm here to present House Bill 311. And with me?
Mr. Chairman, I'm Brad Keithley. I'm president of Keithley Consulting, and I'm here to testify on the bill.
Thank you. So good morning. Good to see some bright-eyed finance members this morning. HB 311 is a bill that I have, this is the second time I've introduced it. I introduced it to previous session. This bill seeks to add an additional tool to our tool belt as we talk about finances and fiscal planning. I think this is a very beneficial tool. It's the sustainable yield, maximum sustainable yield bill, talking about the ICER sustainable plan for Alaska. I don't think this is a concept that's unfamiliar to this committee. I've actually heard it referred to several times as we've gone through the different iterations of opportunities and plans that we have out there, whether it's with the governor's sovereign wealth plan, whether it's with the restructuring or retooling the PFD, or if it's with the percentage of market value. This is not competing with them. However, it would be an additional tool that we could have in our toolbox as we go forward and look at the state's fiscal plan and how we calculate what a sustainable spend is. This bill takes into consideration all sorts of mechanisms that we have at our disposal to plan for and look at what is a sustainable spend for the state of Alaska. And not just for this year, Mr. Chairman, but years in perpetuity. This tool would be something that the governor's office would produce for us, given the parameters that we've laid out in the bill. And it would be a number that we could look to, not necessarily a spending cap, but we would know that if we did spend over that sustainable yield, we would also be incurring debt into the future. So it's really a fiscal planning tool that I think is relevant. We're currently looking at it now. I think we've talked about the $4.5 billion number, and that's a nicer number. That came out of the structure of this legislation that you have before you. I've worked extensively with Scott Goldsmith. Unfortunately, Scott is retired and apparently on a bike trip, so he's not here to talk about it. But with him, Brad Keithley and I have had this conversation over the last 4 years about what a sustainable budget would look like, how we'd calculate it, and how we would operate under that. I think for me, it's a generational bill that will keep us in line with what is the capacity for spend for the state of Alaska. And so with that, Mr. Chair, I really appreciate you hearing this. It's not in competition with any other bill or other fiscal plan that's out there. It is to complement them and to make sure that not only the administration is aware of what our sustainable spend could be, but also gives us a tool in our toolbox to be able to look at the budget, the state budget, and say, if we spend over this amount, we're spending money that really is not a sustainable path forward. So thank you, Mr.
We have a question from Representative Gaddis.
Thank you, Mr. Chair. And as we've heard other plans, if you will, up here in finance, and it's a question that I'd like to kind of be kept in mind as we go through this process. So we heard yesterday, I think it was, I am mixed up on the days at this point, but a plan that we cannot be held accountable to, or is this actually going to be in statute that we will be held accountable? And where I'm going with this is when we ask these questions of other plans, we were told that, and so we're looking a little bit forward, and that's what I like about a plan. But let's say we're not here anymore and somebody else sits in these seats, and it was our understanding yesterday that these are just plans. We can't hold other folks accountable for these. And as we go through that, that'll be what's in my mind, is how do we hold folks accountable, and how do we keep ourselves on this even keel? Because whatever plan we end up with, we've got to make sure that it's sustainable and that it carries through. So I just wanted to put that on with that lens as we go through this process. Thank you, Mr. Chair.
Thank you. Along those lines, Representative Guttenberg.
Thank you, Mr. Chair. And what you're asking here, I'm not sure it's anything different than we've seen in this committee. You know, I mean, there's nothing wrong with this. I mean, in some ways, it's 10 PowerPoints stapled together, you know, and it's always difficult here to have somebody, whether it's Mr. Teal or some high-level economist, sit here and say, you know, and we ask a question, and he'll go 25 slides later, back and forth. It's really difficult to just get a snapshot that, and I don't know if that's what you're looking for, because it's what I'm always looking for. Give me a one-page snapshot of the whole world. You know, it's frustrating, but I think it's, you know, we all want a simple version, render it down, show us what it is, you know, well, and then you start getting scenarios. You know, here's the tax structure under this. Here's the price of oil under that. Here's what happens on Wall Street to the permanent fund. It's very difficult in the end to get that. I mean, I think we should have a week with all legislators in front of you know, in a small auditorium doing that every year so that everybody understands. So I think it's just a matter of whether we pass this or not, of us doing that, you know, because I think it's important. And, you know, regardless of what committee you're on, people feel that they're left out of something, that we have some special insight here, but we get endless slides. We never get a snapshot that just one page tells us what we're on. It doesn't happen. So we should just be doing it ourselves regardless of what the future of this. Thank you.
Thank you, Representative Guttenberg. Representative Guerra.
Thank you, Mr. Chair. Apologize to everybody. I've been bouncing around meetings like many of you, and I apologize that I have to bounce to another one. But I'll ask you questions if I have any questions about the bill. Here's the only question I have. I understand it. I appreciate it. As the part of the bill that you add, it says that the governor should issue a report saying what revenue we have coming in, but he's not allowed to count the net present value of the state's projected oil reserves. And so why wouldn't he be able to count that?
That's a great question, Representative Guerra, and I think as we go through the slide.
Or she.
Pardon?
He or she, the governor.
Thank you for that recognition. Through the chair, I think as we go through the slides, you'll understand the presentation and the thought process behind using our constitutional budget reserve and our permanent fund reserves as a way of an indicator of what is sustainable and what is not sustainable. So I think those will be forthcoming, and as we walk through these slides, I think you'll see how the formula works and how ICER set it up, that the draw, the number, whatever that number is year to year, and how it's compounded and how it's calculated through the various accounts, and then oil revenues and potential oil revenues. So with your indulgence, I'd like to have Mr. Keithley go through his slideshow, and then as we go through that, we could...
One question first from Representative Sadler.
Thank you. Through the chair, Representative Millett. Just to let you know where my mindset is, I'm reading the bill, and I think it says that we do have to look ahead to sources of funds, but it cannot include permanent fund corpus, the CBR, the SBR, or the future value of oil. What's left is oil revenue from taxes and royalties, et cetera, other taxes, and your earnings reserve. So understand that I think you're making the case, at least in the bill language, that we're not to look at future oil, and I don't see anywhere in the language that changes in the law here anything about sustainable. So you'll have to move me off that.
Okay, we will do that. Short order.
Yes, let's hear the presentation. I think it'll answer some of the questions, and we'll probably open up with some additional ones. But without seeing the presentation, we won't get there. So.
Thank you, Mr. Chair. For the record, my name is Brad Keithley, as I said earlier. I'm the one who drew the short straw. Scott Goldsmith would be here sitting in this place if he wasn't on a bicycle someplace between Amarillo, Texas, and Phoenix, Arizona. So I'm the one who answered the phone calls while you got me in front of you. I've included in this presentation some slides that Scott did earlier this year that discusses this bill and the purpose of the bill as part of the presentation. So I'll lower my voice or something when I get to that, so we'll know it's Scott's part. I'm going to do this quickly in three pieces. One, I'm going to discuss a little bit of the background of the bill, which may frankly go to the question that Representative Sadler and Representative Guerra asked. The objective of the bill, which I think is the most important part, and then the implementation of the bill. On the background, this bill was originally introduced as House Bill 136 in the 28th legislature, the last legislature. There were hearings on this bill, two hearings, one in front of the full committee that some of you may recall who were here at the time, and then there was, the bill was referred to the Financial Policy Subcommittee headed by then Representative Costello, and there was a second hearing on the bill in January of 2014. There were no further hearings on the bill after that point. HB 311 is introduced is the same bill as HB 136. I will say that in preparation for the 2013 testimony, Dr. Goldsmith and I, working with Representative Millett, prepared a work draft that improved some provisions and frankly address some of the questions that Representative Sadler and Representative Guerra just raised. That wasn't included as part of the 311 when it got introduced. This legislature they just picked up 136 as it was originally introduced. That work draft we've made part of this testimony and will be included in the record of this hearing and could be adopted as a CS to have those improvements incorporated in it. The objective of the bill is a very simple one. It's to require the administration to calculate and submit each year as part of the December budget process a long-term sustainable budget number that reflects what everybody commonly refers to anymore as the Goldsmith approach, the process of calculating a long-term sustainable number. In terms of sustainability, Scott has, I quote, this quote's from Scott, what he's trying to achieve is a spending level that based on current financial assets and the projected future petroleum revenue stream, which if adopted now could be maintained consistently long into the future, adjusted for inflation and population growth. In layman's terms, we all know that oil prices go up, they go down, they come back up, they go back down, they come back up. We know that our revenue streams are affected by new production that comes on stream, by decline curves. We know it potentially is going to be affected by the LNG project that comes on. And we know that revenues historically, well, revenues follow the up and down of oil prices, follow the up and down of projects. The problem has been that spending has followed that as well. And we've had periods of high spending, followed by periods of low spending, followed by periods of high spending as well. What the Goldsmith methodology does is try to cut through all that and look through the highs and the lows and identify a sustainable spending level, sustainable revenue level that evens all of those out looking forward and gives a line that if we spend it today, we can maintain that same spending level adjusted for inflation and population growth over the long term. If you look at the chart that's on the slide, you'll see the various colored skins are various revenue sources over time. The red, for example, the orange at the left is the CBR. At the bottom are what's called other taxes, about $500 million a year in other taxes. The black is oil revenue from current sources. The green is incremental oil revenues or incremental revenue from new oil that one could anticipate being discovered over time. The blue is revenues from LNG. The gray on top of that is revenue from the earnings off the permanent fund, which has always been included as part of the Goldsmith model. And then the brown that sort of covers in the dip is takes from the earnings reserve. And the line is calculated by the model and says, okay, we're going to have periods where revenues are down, we're going to have periods where revenues are up. This is the line that smooths through those highs and lows. It's the line that it's the level that if you save when you have revenues above that line, you'll have sufficient revenues when you're below that line. You'll have sufficient savings when you're below that line to fill back up to that sustainable level. And the goal of this process is to try to treat all generations fairly, to try to treat all Alaskans fairly, and have a consistent, stable, reliable, predictable revenue stream and spending stream that stretches out over time so that we don't go up and down. The goal of the bill is to provide a number that looks through the ups and downs of the commodity cycle and identifies a stable, long-term, sustainable budget number. This bill, 311, is not a spending cap. It doesn't purport to limit spending, although it could be used for that, and frankly, I've advocated for that in the past. It's not a fiscal plan. This bill is not a fiscal plan. It doesn't say that this is the plan of the state of Alaska, that we're going to follow the Goldsmith methodology, although it could be used for that, and I've advocated for that in the past. But this bill doesn't do that. In the form of HB 311, it is a guide for what that sustainable number is, calculated by OMB, provided to the legislature each December as part of the budget, so that the legislature then has that information as it undertakes its deliberations in the following session to look at what that sustainable number is over the long term and to take it into account in making its deliberations. It's not saying you have to abide by that number. It's not saying that's the fiscal plan of the state. This bill, all that this bill does is provide you that information. And frankly, everybody talks about the Goldsmith methodology, talks about the numbers that come from it. Scott's not always going to be around. Scott's not always going to is not always going to be calculating this number. Scott's going to take bicycle rides on occasion, and this institutionalizes and formalizes the process, a process of getting that number before the legislature on an ongoing basis, so the legislature can consider it, and the governor, the administration, can consider it in the formulation of their fiscal plans, their fiscal approaches each year. The origin of the model, frankly, was very simple. Scott was doing some work for Northrim Bank for Mark Langland and Joe Beadle, and the question was,
brief at ease. On the record.
Thank you, Mr. Chairman. The origin of the plan was frankly in response to a question from Mark Langland and to Scott, from Mark Langland and Joe Beadle at Northrim Bank, saying, what would we need to save today in order to be able to have revenue for tomorrow when oil prices go back down? Look forward, develop a methodology that looks forward, knowing that oil prices go up and down, knowing that revenues go up and down in this state. What methodology, develop a methodology that would tell us what we should be saving today when oil revenues are high and what we should be taking from those savings when oil revenues are low in order to have a sustainable revenue, sustainable spending number over time. So that's where the origin came from. The chart on the right is the chart you've seen before from Ledge Finance Division. It shows revenues in the green spikes. It shows spending in the bars. And it shows that over time we've had high revenue periods, low revenue periods, followed by high revenue periods, followed by low revenue periods. And frankly, I'm here to say we're going to have higher revenue periods than we have now from our traditional sources out into the future. And so this methodology is trying to look through that, look into the future, and say what's the sustainable number over the long term that treats all Alaskans fairly and has a consistent level of revenue. It creates, this bill creates a focus, provides a focus on the long-term outlook. If you assume, what we've had in the past is we've seen revenues go up, and frankly, we've spent to those revenues. We've seen revenues go down, and frankly, we've chased those revenues down, and now we're looking at a situation where we're going to try to fill revenues with additional sources. I'm not arguing good, bad, or indifferent, but you've had this continuous cycle. HB 311 is there to create a tool to help focus fiscal policy as we go through these ups and downs, focus fiscal policy on the long-term outlook to look through the highs and the lows, and frankly, something that's critical to a commodity-based economy. When you've got a commodity-based economy, it goes up and goes down and goes up and goes down. You need something that looks through that. That's what this does. If you assume the future is always like the present at high prices, you become too optimistic and current spending overshoots the mark. I think that's what happened to us in 2011 through 2014. We assumed oil prices were always going to be $120. We assumed we were always going to have high revenues. And frankly, I think a lot of people were saying, including people in this room, that we're spending too much. But we had the money and we did it. Pessimism is an equal problem. When you have low revenues, low prices, and you assume that you're always going to be in low prices, you start pulling levers like taxes and PFD cuts to fill the revenue gap when maybe you don't need to do that. When you look at the long term, when you look at the revenue cycle, you look at where the revenue cycle is going, you see that, okay, we're going to get through this. We're in a low revenue cycle. We're going to have high revenue cycle. What's the level of spending we ought to be maintaining during this period that takes into account what's coming in the future? So that's what this bill does. Again, it doesn't set a statutory cap. It doesn't say you have to do this, but it provides you the information that enables you to do it. Scott, these are Scott's slides. I'll run through them quickly in the interest of time. These are slides he prepared for this bill earlier this year when the bill was first introduced. I could change my voice or something, but the slide color's different, so you know I'm speaking as Scott now as opposed to me. It recognizes, the approach is to recognize and manage our petroleum wealth endowment like a depletable asset. That is to say, look, we're going to have high revenues off our petroleum wealth. We're going to have low revenue off our petroleum wealth. What's the number that cuts through those peaks and valleys and is a consistent level, a sustainable level through all that, and values, looks at those future revenues from oil and values them in a way that gives you a number that you can use for that consistency. Petroleum wealth of the owner state, this is Scott's calculation of what our current wealth is, the state's current wealth. Both our fiscal assets that are in the bank, like the permanent fund, constitutional budget reserve, the PCE, various other accounts that we have stored away that are producing returns, and then looks at in the ground, the oil in the ground. Now, sometimes we get confused about this. People go, well, how can you look at what oil in the ground's worth? I mean, is somebody going to come buy our oil? Is that what the value is? It's not it at all. All this is the net present value of the estimated future earnings stream of our oil. It's not trying to sell it. It's not trying to value it in some way that some oil company would come buy it. It's simply saying, let's look at what the future earnings stream is from our oil that's going to come into the general fund, and let's take the net present value of that, and then let's take a portion of it. It's frankly the same thing that we're doing with the permanent fund. We're taking a portion of the value of the permanent fund or we're talking about taking a portion of the value of the permanent fund into revenue. This is simply looking at the long-term value of the earnings stream and trying to smooth it out, not taking revenues when they're high and not having revenues when they're low. Sometimes there have been criticisms of this approach by saying, well, oil goes up and down, and some years, you may think it's going to be high oil prices, and some years you may think it's going to be low oil prices. This approach that Scott's got has adjusted for that, and he's now taking the 3-year average, the trailing 3 years of oil prices in terms of calculating what the long-term value is, of what the long-term net present value is. So the combination of those two, the money in the bank, the value of the money in the bank, and the net present value of the anticipated earnings from future petroleum and LNG is roughly $125 billion in total, $64 billion in the bank, $61 billion in the ground. So how much can we spend today? What's the calculation of the sustainable revenue? This is the approach he goes to. He treats both the permanent fund, the fiscal assets and the oil assets, the net present value of the oil assets, the same. Takes 5% of those, a number that's familiar to some of you as a portion of the earnings stream. He subtracts 0.8% because what this approach is doing is trying to adjust for both inflation and population growth. It's trying to keep the revenue level the same for future Alaskans adjusted for population. So if our population is going to go up, it's trying to keep the revenue level per Alaskan the same in the future. Other methodologies that you had in front of you don't do that. They simply say, we got X amount today, we're going to have X amount tomorrow. They're not adjusting for population growth. Scott's methodology does. That's what the minus 8.8% is. That's the effect. That's the implementation of that. So it's 4.2 times the 125 billion, 5.2 billion minus the permanent fund dividend. This Scott's approach maintains the full dividend, assumes the maintenance of the full dividend, subtracts that out from the revenue stream from the long-term sustainable revenue level, and then adds in the non-petroleum general fund revenues, the 500 million we've got, the $500 million we've got in other taxes that sort of isn't varying much from year to year, and comes up with the general fund maximum sustainable yield for FY 2017 through that calculation of 4.4 billion. That is the number that Scott is saying, that this methodology would tell you if we had this bill. It's the number that the methodology would tell you we could spend today from our savings accounts, our revenue plus savings accounts. We could spend today without adversely impacting the future. It also says when we get into periods of high revenue levels again, that's the number we need to keep spending, adjusted for inflation and population growth. We need to save the remainder to get ready to both pay back what we've pulled out of savings in this low price cycle and to put back in and to put in savings to get ready for the next low price cycle that's going to come after this one. So it's both, this sustainable revenue number is both what you can spend when you're in a low cycle, what's appropriate to spend to treat all Alaskans fairly, all generations fairly, and the limit on what you should spend when we're in a high revenue cycle, again, in order to treat all Alaskans fairly, to take that to take that excess amount and put it into savings. And again, this is just under 311, HB 311, this is a number you're getting as information. You're not signing up to this is a spending cap or this is the fiscal plan. What 311 does is says this is the number you're going to get on an annual basis to evaluate as you go through the budget process. And this chart is simply Scott's depiction of the result of staying on this sort of sustainable budget approach. In the past, we've lived mostly from petroleum in the ground. We're going to continue to live on revenues from oil going forward. As I say, oil prices go up and go down. Production goes down faster sometimes than it does others. We have LNG out there in the future. We have some projections of new fields out there that are of significant size. We're going to have petroleum in the future. We're going to have petroleum revenues in the future. We do need to face that we have a declining petroleum reserve base. Petroleum's not a replaceable commodity. Once you take it out of the ground, it's gone. But we're going to continue to have that. And so this is a depiction of showing over time what will happen is this approach will keep telling you that more and more money is going to be taken out of earnings to supplement, but we'll have the money there because we will have saved it during high revenue times. The implementation, frankly, this talks about the full implementation. This was Scott's discussion of the full implementation of what he calls the maximum sustainable yield approach, the sustainable approach. The point we're discussing here is bullet 3 on this side. HB 311 discusses bullet 3 on this slide, establishing a monitoring system to track the nest egg value, set the maximum sustainable yield target, and track progress towards sustainability. There are other steps if you want to go to a full implementation of maximum sustainable yield. If you want to make it your fiscal plan, the other steps on this slide discuss those. But all we're discussing here with HB 311 is the third bullet. There have been other perspectives on this approach. One is the chambers used it the Alaska Chambers used it for a number of years to set the recommended spending levels that they've included in their legislative packets that they've talked to you about when they're here earlier in the session. Commonwealth North looked at this in detail in February of 2013, looked at Scott's approach in detail in February of 2013, and the words here are interesting. I thought I would highlight them on this slide. As of February 2013, the concern was the state is spending money at an unsustainable rate. If it is not checked, extreme measures such as diverting all permanent fund dividends and or instituting state taxes could become necessary to sustain spending in state programs. The state has an urgent need to develop the practice of creating successive long-term strategic plans with annual budgets based on maximum sustainable yield of the state's primary assets. So back at this time, we were in a high revenue cycle, and we were Commonwealth North was concerned that we were spending too much, we weren't saving enough to protect ourselves during a low revenue cycle. Now, the reverse of this is true, but the reverse is true. Being too pessimistic about the future leads you to take steps that you shouldn't take, and this is providing information to enable us to avoid it. So, HB 311, in sum, is simply a tool, not a mandate, but a tool to help keep Alaska fiscal policy focused on the long term. It is a codification, an attempt at codifying the methodology that Scott's used over a number of years that's provided this information to ensure that the legislature continues to have that information on a going forward basis in future years. Thank you, Mr. Chairman.
Thank you for the presentation. We have questions from committee for Mr. Keithley or Representative Millett. Representative Gaddis, questions?
Thank you, Mr. Chair. And thank you for your presentation, Representative Millett. Excuse me, my colleague from Anchorage. I'm so sorry. Oh, thank you, Mr. Keithley, for your presentation. And I've heard your presentation over the last few years, and I too agree that we have to have a sustainable budget. Clearly more this year than any other year has it become more apparent. But there are folks that may disagree, and if you don't mind, that's where I'm going to ask my questions from. I'm going to play a little bit of devil's advocate, if you will, and I know you're up to the challenge. So if you don't mind, I have a couple questions, but they're what folks do say when they hear your presentation. So Why would we assume 125 billion in the bank now and into the future, then exclude our major savings accounts from the maximum sustainable yield formula?
So that's a deficiency of the bill as it was originally introduced. The bill as it was originally introduced was sort of a long debate between Legal and Representative Millett's office about what language should be included in there. When it got drafted and filed, it really didn't reflect Scott's intention. The work draft that was submitted back in 2013 and can be included as a CS here changes that language in a way that now reflects the approach and the methodology that I just described.
Yes, Mr. Keithley, to stick with our own protocols, usually when you reply to a question, you address it through the chair. No problem.
Mr. Chairman, thank you very much. I'm sorry.
Representative Gaddis.
Thank you, Mr. Chair. Through the chair, Mr. Keithley.
Representative Gaddis.
Thank you. The changes that the bill makes to statute seem to nullify the basis of a maximum sustainable yield principle. Your maximum sustainable yield calculation for fiscal year 17 is 4.4 billion, not including the dividend. Where would we get the cash if we are excluding those savings accounts?
Through the chair, I get it the second time. through the chair, Representative Gaddis. Again, frankly, that's a deficiency of the way that the bill was drafted. We're not excluding things. The work draft replaces that and reflects the methodology that I've been through. So we're not excluding those accounts. We would draw. I mean, the methodology looks forward and says we draw from savings when we're in a low revenue cycle. We add to savings when we're in a high revenue cycle. I appreciate the basis for those questions given the bill is drafted, but again, that was a function of sort of a long debate between us and Legal.
One more, Representative Gaddis.
Thank you, Mr. Chair. And I think those are some of the reasons I wanted to ask the questions, so I wanted to put on record. And my last question is, if the maximum sustainable yield plan works, then why are we broke in fiscal year 2022?
Through the chair, if we use the maximum sustainable yield plan, we're not broke in fiscal year 2022. We limit spending to the maximum. If we use it as the methodology, we limit spending to the level that we can sustain from our current revenue sources using savings, and then in high revenue cycles, we limit it to that same level, fill savings for when we get to the other side. So it doesn't lead us to being broken. Quite the contrary, it leads us to being solvent and healthy in fiscal year 2022.
So, Mr. Chair, thank you for allowing me to follow up on those three questions, because I wanted to put on record, there are naysayers out there that have those challenges, and at these fiscal times, we need to take all of the plans and really look at them and really explore them. So, thank you, Mr. Keithley, for presenting and bringing that forward. Thank you.
Representative Wilson. Representative.
And just to be clear, and there might be some confusion because I have two bills in. I have the companion bill to a bill that's on the other body that does restructure the permanent fund. This bill can be used with any of the plans set forward. It can be used with the percentage of market value plan. It can be used not so well with the sovereign wealth plan, but it can be used with the other bill they introduced. This is a tool. This is a mechanism for determining what the spend is. What would be sustainable to years outward. So it's not something that, this isn't the panacea. This is just saying that this is what we can spend going forward. Every year that calculation will be made based on the assumptions that we have. And so it's for us, it would just be, okay, we're going to spend $4.4 billion this year. If we decide to go over that, we know that there will be in future years a problem, that we will have to make that up somehow, whether we bet on higher oil prices or we bet on a higher throughput through the pipeline. But this gives us a guide, and we're using it now. And so when people ask me, well, where does that 4.4 or 4.5 billion dollar come from? I tell them, well, there's a formula that we get there, and this is the formula. It's not in the bill that you have in front of you, but There is a formula that Scott uses to get to that number based on the assumptions of what we have assets as a state. So it's not competing with anything. It's not competing with another plan. It is just an indicator of what we could spend based on assumptions that we use. Mr. Chair.
Thank you, Representative Millett. Representative Wilson, followed by Co-Chair Newman.
Thank you, Mr. Chairman. So the 4.4 billion, is that for general funds, is that both capital and operating?
Through the chair, Representative Wilson, yes, it is. It's total spending. It is operating, it's agency operations, statewide operating, and capital. Total spend, total draw. The formula really doesn't care what category spending is in. It's money being taken out of the state treasury. That's what the formula is trying to calculate.
And a follow-up, Mr. Chairman?
Representative Wilson.
So how do you reconcile if you move some of your general fund spending to perhaps other funds that are out there? Do you go ahead and count that in the 4.4 billion because it's really not general fund money, it's designated general funds now? How do you, I'm just trying to figure out how you reconcile, does it change the number? Or should we still count those as, even though we fund switched in the 4.4 billion?
Through the chair, Representative Wilson, this frankly, this formula doesn't get into that. It says, here's your revenue number. Here's what you should be spending. There are DGF pots of money that get spent for designated general funds. PCE is a good example of that. You've got an endowment that sits out there that spins off revenue and is going to PCE. If you don't include PCE in this formula, then that sort of happens off book. You have to be careful as you evaluate this tool each session, as you apply it to the budget to make sure you're getting apples to apples. This tool doesn't delve into the UGF versus DGF distinction, but it does tell you this is the pot of money you've got to spend for operating, state agency operations, statewide operations, and capital. This is the pot of money you got.
Thank you.
Co-Chair Newman.
Thank you, Mr. Chair. Welcome, Majority Leader and Mr. Keeley. I'm just trying to envision what we're dealing with today. We're dealing with last night. We've got about $800 million in tax credits that we put out to incentivize exploration, so we have more production. It helped with the Cook Inlet Recovery Act. It was a good program. I think it worked well. Are those tax credits in budget or out of budget?
Through the chair, Representative Newman, they're inside this $4.4 billion. That expenditure is taking money out of the Treasury and depleting the revenue side, depleting the revenues that this state has, and is being spent on something, just like Medicaid, just like health and social services, just like K through 12. It's the same type of spending, and so this would tell you, this calculation would say all that spending needs to be to be sustainable, long-term sustainable, needs to be within the 4.4, 4.5 number. That 800 million counts toward whether or not, counts on the spending side toward whether we're inside that number.
Follow.
Co-Chair Newman.
Thank you. And this is the problem that we're having right now is under 21 and other legislation, we put out tax credits to incentivize exploration for oil because we had our throughput running at 6 to 7% rate of decline. Because we had to offer those credits, we now have more oil coming through the pipeline. We've reduced that slowdown or that run through considerably, which raises our revenue, probably more in higher oil prices, but now that the price of oil is down, it's considerably lower. The problem that we're running into is if when we did that, oil was running $100 a barrel, we had the ability to try and incentivize that, and I think it was a good move to do that. Oil is still the majority of what we run our budget on here, about $780 million as of right now with oil revenues in the last forecast. But we had to spend extra dollars to incentivize for those credits, and so we have an expenditure that's above the $4.5 billion, so that in the future we have more revenue coming in because of the decline curve and the flow put to maintain that 4.5. So we had to spend a couple of bucks to be able to make a couple of bucks down the road. So how do you level that out?
Through the chair, frankly, this methodology does a very good job of that. This methodology looks forward and says, you're going to have X amount of oil production going forward. It factors in, this methodology factors in the consequences of those credits, the production resulting from those credits, and it applies a price to them, a value to them going forward based upon whatever price projection is being used in the formula. So it's giving you the value out in the future of what that investment has produced. And it's telling you, even with that value, even with that additional value that you're getting out of these credits, your spending level still should be at $4.4 billion. That if you spend more than that currently, you're essentially robbing from future revenues. You're essentially robbing from savings from future Alaskans. Now, again, this bill doesn't tell you you have to cap it at 4.4, but it's telling you what you're doing. It gives you the information to know what you're doing when you're doing that.
Mr. Chair.
Co-Chair Newman.
That's what I'm trying to envision in my mind is, because we had to spend a few extra, do you manage that out and say, okay, our expectation on that, just in the last 3 years, we've increased throughput 5%, from a -6 to about a 1 or 0. So do you envision a mechanism where we can say, okay, we've had a future investment here so that we have continued investments down the line in a declining throughput? I'm trying to figure out how to average that out because we had $800 million in credits that I don't think that we expected that much in credits coming back. We're trying to pull back some of the ones in Cook Inlet for exploration. That's not needed now. We got 12 years of known reserves there, but we don't want to really touch Prudhoe Bay. We want to make sure that we maintain the viability of our oil and gas industry there. So I'm just trying to figure this out because we have the extra. We're close right now. We're down to about 4.3 total, with the operating and capital. 4.4. So we're there about now, but we have these credits that are dogging us here. But it's for the future so that we don't. And I'm just trying to figure out a mechanism. Is there a way we can maybe figure that out with a 5-year average then, to maintain that 4.5? Is what I'm trying to get to.
Go ahead.
Through the chair, I've gone back to a slide that has the graphic depiction. I'm sorry to have not said this when Representative Gutenberg was still in the room. This is sort of he wanted a one-stop shop. He wanted a one slide. He wanted a single place to go. Well, this graph to me is that single place to go. This graph shows the calculation, shows the various revenue levels, shows the calculation of the long-term sustainable revenue number. And the reason I pull this up, Representative Newman, is if you see one of the skins on the graph is in green. That's new oil, and in part that new oil is being factored in, coming from the credits, coming from maintaining exploration programs, coming from developing additional production capacity going forward. It is an estimate of what that's going to result in, and then you apply the anticipated oil prices to it, and you see what that's valued out there, and even taking that into account. It still brings you back to the 4.4 number. Now, frankly, what that says is maybe you're spending too much on oil credits, or maybe you're spending too much on other things. But from an overall spending standpoint, you should be at 4.4, 4.5. Spending any more than that, is impairing the dollars you're going to have to sustain that number into the future. It's not trying to tell you don't spend it on oil tax credits, don't spend it on Medicaid, don't spend it on HSS, don't spend it on K through 12. It's just telling you don't spend more than the 4.5 billion. And to the extent you do that, you're running yourself into problems. It's taking into account the consequence of those oil and gas tax credits, as well as a number of other things, the SB 21 rates, taking that into account in projecting out what the future production levels are going to be.
Yeah, that's what I'm kind of getting to. Several years ago we took $3 billion out of the CBR, which would have been an expenditure, I think, under this. But because we paid down PERS, we have over $1 billion less in actuarial payments. So we would have been over the cap, so that we didn't. So this year's our payments were 217 instead of.
That was. I'm sorry. Through the chair. That was that was a little bit different because the effect of paying out that $3 billion was to lower the operating costs going forward. PERS TERS would now be over $1 billion given the projections at the time if we hadn't taken that $3 billion out. So it's lowered the operating costs. It's helped get us down below, get us toward the 4.5. Again, the number you're going to get out of this methodology is going to tell you what your number should be. In any given year, you can say, look, we're going to spend more than this because we think there's a bang for the buck in doing it. The PERS TERS payment's a good example. We're going to spend $3 billion, but we know that's going to enable us in the future to keep below the 4.5 or help us keep below the 4.5 because it's going to lower the operating costs. In any given year, you can make that judgment. This is just telling you, this is giving you the information that tells you that you really need to think about it hard if you're going to go over the $4.4 billion. You really need to have a good reason. You really need to understand what the long-term impact of it is. It doesn't tell you you can't do it, but it's telling you that it is likely to have an impact, and you really need to think through that long-term impact hard. And frankly, that's a great thing of this. It gives you a long-term perspective, forces you to think about the long-term consequences of your acts when looking at it year to year, you don't really do that.
Yeah, and just one more.
Representative Newman.
And that's kind of how I see this, and that's why I mentioned it's somewhat out of budget because it's an accounting over here that you have to invest for the future. But then we've got your day-to-day operations, formula, non-formula, your formula with education and Medicaid, your statewide, with TERS, PERS, and such like that. It's more of your day-to-day in core operating budgets, and then some of it an out formula, but it is an expenditure that should be recognized that invests for the future to continue to be able to have those investments coming back in, is what I kind of meant, is out of budget cycle somewhat.
If I can respond to that, Mr. Chair.
Go ahead.
Yes, but I would say it's different than PERS TERS. PERS TERS was a one-time $3 billion payment that had a payout in terms of lower operating costs. Right now, with oil and gas tax credits, those are continuing. I mean, yes, they're $800 million this year, but they're X hundred million next year and X hundred million the year after that. If what we were doing was creating a transition fund and putting money into a transition fund to transition out of oil and gas tax credits, it would look a lot like that, and it would have that explanation, the PERS TERS explanation. But that's not really what we're doing right now. What the bill does right now is sort of put them on a slow glide path down, but we're still paying year after year after year. So, again, this is not saying you can't do that. It's just saying when you do it, you need to consider the long-term consequences, and here's the baseline against which you consider it.
I can envision a little bit now how that would work.
Representative Sadler.
Thank you, Mr. Chair. I believe I do understand the maximum sustainable yield concept. I've read a number of the past iterations that Dr. Goldsmith has done, and somewhat tongue-in-cheek, it sometimes reminds me of saying an 18-year-old can buy a house because he's going to earn $1 million over his lifetime. But actually, I do understand what the goal is and the caution it tries to get to the legislature. But I have to ask, I'm not clear as to what tool is actually created by this bill. It seems to direct the governor to do what he should do anyway, which is just, in a general sense, look ahead to what money is available for spending. But what still is puzzling to me is the bill language itself says nothing about sustainability. It seems to bar what you're actually advocating should be done. So,
Through the chair, Representative Sadler, I don't know if you might have left the room when we talked about the flaw in the technical writing of the bill that you have before you, and we do have. We recognize that, but in expedience, I introduced the legislation, and I do have a fix, and I do have a formula here that I can share with you and that the co-chairs have that explains how we get there and how the calculation works, because this bill does a very poor job of explaining what maximum sustainable yield is and how going forward we would do that. But we do have language here that we've given.
There'll be a new CS.
And I'll wait for the CS. Thank you.
And I think it will explain. And one of the things that I wanted to add to Mr. Keithley was, Representative Newman, you're exactly right. Those decisions that we made on PERS and TERS, they were great decisions. They were carefully weighed out, and we knew the fiscal impact going forward on that would lower our draw. And those things that we can do like that, I think, are beneficial. This doesn't say we can't do them. What it says is, if you're going to do something outside of this, here's your outcomes. Now, with PERS and TERS, with the deposits that we made, we could have shown, in addition to this number. We could have shown what that would save us in the future going forward, which it is now, which we're receiving. So it's just a mechanism. It's just a number in time of what we can spend and how it will affect us. If you can make the case that going forward that PERS and TERS deposit would have lessened our draw, it absolutely works in concert with that. And I think the transitional fund that Mr. Keithley talked about for oil and gas tax credits is another mechanism that we could, if we had more time, could develop and capitalize a fund and use that to pay off our credits. And we would see that as a benefit, and it would work in concert with this maximum sustainable yield. So again, it's just a mechanism so legislators and the administration can know what we do beyond this will have consequences, and what those consequences are in years going out.
Thank you, Representative Millett.
And that's exactly what I think too. You know, I think that transition fund is a good way to envision it. You know, if you invest here, this is our expectations, and you have set expectations, you know, then you have rules. And if you're guided by rules, you'll get to where you need to be, and you stay within those rules. Thank you, Mr. Chair.
This bill will be coming back to us. We have a CS being printed, so we will have an opportunity to ask questions again. Representative Munoz.
Thank you. Thank you both for the presentation. I think the information as a guide is very important. I think it would be a very important tool to have. Representative Newman, the representative from Big Lake. I'm going to have to get used to the more formal requirements of the committee, but the representative talked about the impact of the credits going forward. What about the intangible or indirect impacts of the net operating losses that are really they're more difficult to calculate on a kind of a sustainable draw calculation? And how did you account for those?
Through the chair. You want to do this?
Go ahead.
Mr. Keithley.
So again, this is a big picture tool, but the future revenue line is a prediction of future revenues under the existing tax code, right? So SB 21 stays in place, and it produces a certain amount of revenue over a prolonged period of time. The net operating losses sort of factor in that, right? So net operating losses are part of SB 21. They're part of the calculation of profits. They're part of the calculation of the revenue stream we're going to see. They go into the calculation of the net present value. That affects the net present value of the oil of our future oil stream, and then goes into the calculation that way. So it's in there. It's not. I mean, I can't go into a precise piece of the statute and say this is exactly where it is, see where it says NOLs, but it's in there in the calculation of the net present value of the future oil stream. Is that responsive?
Okay, I'm going to go ahead and, because we have limited time, and at this time I'm going to open up House Bill 311 to public testimony. Is there anybody in the room that would like to testify to HB 311? Seeing none, is there anybody online? There's nobody online. I'll close public testimony. At this time, I'm going to set House Bill 311 aside as there is a sponsor CS, and we'll be bringing this back. And with that, our next House Finance Subcommittee meeting, or Finance Committee meeting, is today, Wednesday, April 13th at 1:30 p.m. And at that time, we'll be hearing House Bill 245, Permanent Fund Deposits, Dividends, and Earnings. And with that, at 10:50 a.m., we are adjourned.